अस्सलातु वस्सलाम अलैका या रसूलुल्लाह वस्सलाम अलैका या हबीबल्लाह। प्यारे व्यूवर्स, कैसे हैं? उम्मीद करता हूँ आप सब लोग खैरियत से होंगे और अल्लाह ताला आपको सेहत के साथ लंबी ज़िंदगी अता फरमाए। मेरी आप तमाम दोस्तों से रिक्वेस्ट है कि मेरे इस चैनल को सब्सक्राइब कर लें और घंटे और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुंच सके। आज का जो टॉपिक है नाजरीन, बहुत ही इंटरेस्टेड है। आप इंशाल्लाह ज़रूर पूरी वीडियो ज़रूर देखनी है आप लोगों ने, उसको स्किप नहीं करना। बहुत शुक्रिया। पब्लिक नॉसेंस, सेक्शन 133, conditional order for removal of nuisance. Whenever magistrate of the first class considers or receiving a police report on other information and on taking such evidence, if any, as he thinks fit, that any unlawful obstruction or nuisance should be removed from any way, river or channel which is or may be lawful used by the public or from any public place, that the conduct of any trade or occupation or the keeping of any goods or merchandise is injurious to the health or physical comfort of the community, and that is consequence of such trade or occupation should be prohibited or regulated, or such goods or merchandise should be removed to the or the keeping, that the construction of any building or the disposal of any substance as likely to occasion conflagration or explosion should be prevented or stopped, or that any building, tent or structure or any tree is in such a condition that it is likely to fall and thereby cause injury to persons living or crying on business in the neighborhood or passing by, and that in consequence the removal, repair or support of such building, tent or structure, or the removal or support of such tree in necessary, or that any tank, well or excavation adjacent to any such way or public place should be fenced in such manner as to prevent danger arising to the public, or that any dangerous animal should be destroyed, confined, or otherwise disposed of. Such magistrate may make a conditional order requiring the person causing such obstruction or nuisance or crying on such trade or occupation or keeping any such goods or merchandise or owning, possessing or controlling such building, tent, structure, substance, tank, well and excavation, or owning or possessing such animal on or tree within a time to be fixed in the order. To remove such obstruction or nuisance, or to desist from carrying on or to remove or regulated the keeping thereof in such manner as may be directed such trade or occupation, or to remove such goods or merchandise to be regulate the keeping thereof in such manner as may be directed or to prevent or stop the erecting of or to remove, repair or support such building, tent or structure or to remove or support such tree or to alter the disposal of such obstruction substance or to fence such tank a well or excavation as the case may be or to distract, confine, and dispose of such dangerous animal in the manner provided in the said order. So, if he objects to do so, to do to reap to appear before himself or some other magistrate of the first class at a time and place to be fixed by the order and move to have the order set aside or modified in the manner hereinafter provided. Number two, no order duly made by a magistrate under this section shall be called in question in any civil courts. Explanation: a public place includes also property belonging to the state, camping grounds and grounds left unoccupied for sanitary or recreative purposes. Commentary. Number first, scope and extent. Section 133 CRPC aims to enable a magistrate to make speedy redress when public nuisance falling within the six categories enumerated in the section is being committed. A bare reading of section 133 CRPC would indicate that magistrate before he passes a final order he has to pass a conditional order which in fact is a kind of show cause notice to the person who is indulging in an activity which has prompted proceedings under the aforementioned section. The first part of subsection 1 of section 133 CRPC refers to various instances and situations which may constituted a public nuisance and thereafter stipulates a course to be followed by the magistrates who is seized of the manner which reads as under. Such magistrate may make a conditional order requiring the person causing such obstruction or nuisance or crying or such trade or occupation or owning, possessing or controlling such building structure within a time to be fixed in the order to remove such obstruction to nuisance or to desist from carrying on some other magistrate of the first or second class at a time and place to be fixed by the order and move to have the order set aside or modified in the manner hereinafter provided. It is only after complying with his provision that the magistrate can pass an absolute order in terms of Section 136, Section 137, and Section 139 of the Criminal Procedure Code 1995. PCR LJ 385. Question as to what constitutes public nuisance is a matter of public import and as such extents of a remedy in favor of petitioner under the Punjab local government order does not deny the district magistrate of his power under this section 1995 PCRLJ 385. In terms of parameters to be spelt under section 133 CRPC, instances of public nuisance may include: first, the unlawful cutting of a public road; two, the second, the place of erections on roads; third, the passage of cattle through a narrow streets, thereby obstructing public way. Fourth, the effect of overflow of serve water rendering the roads unfit to be used. Fifth, Fifth, all encroachments on public roads, pathways, and recreated grounds and parks. Sixth, an obstruction in the channel of a public canal. Seventh, a noise during some lawful trade which is injurious to the physical comfort of the community. Eighth, discharge from a factory into a river or canal of such a substance which may be injurious to the physical comfort of the community. Ninth, accumulation of municipal waste like sewage, refuse, sludge, and human excreta. And tenth, such a use of loudspeakers which causes general public any annoyance and announces discomfort in an area 1995 PCRLJ 385. Magistrate subdivisional magistrate or district magistrates are competent under this section to take cognizance and to entertain an application and to act on the information furnished in that behalf 1993 PCRLJ 1463. Magistrate should pass a speaking order by adopting procedure provided by section 133 CRPC 1995 PCRLJ 385 1994. SCMR 665. He should hold an injury in case of denial and ask the respondent to provide proof in support of denial. Inquiry into the merits of the causes by visiting the sports in is not proper, rather weighty. It's the proceedings 1992 Meldy 67. Magistrate can invoke power under this section in the interest of society in the prevention and improvement of environment PLJ 2002 LAH 2014. Number 2. Public nuisance requirement. Firstly, the action complained of is injurious to health or physical comfort of community. Secondly, trade or occupation complained of is caused to public in general 1990 PCR LJ 1928 ejection Order Section 142 1 can be issued as and when necessity arose PLD 1964 SC 391 roof in a dispediated condition does not passage in dispute denied section not applicable PLD 1991 AJ and K 35 revision competent 1999 PCR LJ 1477 object of section 145 CRPC is to prevent disturbance to public tranquility and to protect the realm from roots and civil commission in cases where disputes over property are likely to cause breach of peace 1919 PCRLJ 1222 power subordinate to power of civil court 1990 PCRLJ section not applicable on the complaint of breach assessment proprietary rights are that construction violated rules 1998 PCR LJ 1455 magistrates to exercise powers by observing the rules of natural justice and the principles of ad alteram partem by giving necessary notice to all the parties concerned and hearing their grievance 1999 PCRLJ 99 PCRLJ 31 3. Improvement of environment magistrate can invoke power under this section in the interest of society in the preservation and improvement of environment PLD 2002 LAH 555. Number 4. Business of heads and skins. Business of heads and skins magistrate empowered to remove nuisance 1999 PCRLJ 31. 5. Jurisdiction of civil court. Jurisdiction of civil court not bad where civil right of party to be determined PLD 2000 LAH 53. Number 6, issuance of conditional order. Issuance of conditional order is must recording of evidence prior to issuance of such notice is not mandatory. Order should be such as to afford by its terms to the person to whom it is addressed as to what that person was to do in order to comply with the same. Procedure given 2000 PCRLJ 1702 7 number. Encroachment encroachment, however small or a public road, must inevitably result in obstruction to person who may have occasion to use such road and is therefore a public nuisance 2000 PCRLJ 1702. Number 8, SIC uteri 2 at alienum non ledas. So use your own property as not to injure the rights of another. Use of private property may given as to raise to public nuisance 2000 PCRLJ 1702. 9. Pakistan Environment Protection Act 1997 subsequent legislation on the subject would be necessary and implication repeal earlier law to the extent of mutual inconsistency or repugnancy. PLJ 2001 LH 652 2001 CLC 1139. Number 10th, permission of the Advocate General. Advocate General has right to file a suit either himself or by giving consent in writing to two or more persons in whom the right to sue is vested 2005. आखिर में मेरी आप तमाम दोस्तों से रिक्वेस्ट है कि मेरे इस चैनल को सब्सक्राइब कर लें और घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुंच सके। तब तक के लिए मुझे इजाज़त दें। कल इंशाल्लाह नए टॉपिक के साथ हाज़िर होऊंगा। अल्लाह आपका निगहबान।